Welcome in, everyone. It is Thursday, November 4th, 2021, and welcome to State of the Family Courts. So we had a guest scheduled to come on tonight, but being a lawyer sometimes happens, so we had to reschedule them. I'm really excited to have her on, but we thought we'd take this opportunity to have another Q&A. So we will, tonight, we'll spend 45 minutes to an hour just answering some questions in regards to family court, child support, child custody. So I know we've done it a couple times in the past, so get your questions in the comments on Facebook or YouTube. And I think diving into that, I've seen something recently that I think needs to be addressed within our community, within the equal and shared parenting community. And it's something I actually saw on Monday. So I was in court telephonically on Monday with a client, and we're sitting there on the phone. We are waiting for our case to be heard, and the case just prior to ours, the father was actually granted full legal and physical custody, and the mother was not happy about that. It's a situation where she's claiming that, not unlike many individuals who are watching this show, claiming that the father had been withholding the child from her for a period of several years. And she was clearly knowledgeable of the law. She'd clearly done her research. And she went on about a 5-minute rant about all the federal lawsuits she was going to file, how she demanded the judge recuse themselves, and all these different things. I'm going to file a RICO lawsuit against you. And this judge, very kind, very even-handed judge, one of my favorite judges to be in front of, just simply asks her why her arguments she's making right now matter. And he was getting at the point that they don't. And I've seen an uptick recently. I think social media has spurned some of this, of many fathers going, just burn the bridges, throw everything out there, and start threatening judges, start threatening evaluators that they're going to sue them, that they're going to do this, they're going to do that. It's at the end of the day, that's not an effective way for you to be successful in court. Not saying you're not right. I'm not saying it's not justified. But what I'm saying is that attacking individuals in the system, no matter how right you may be, it's only going to harm your individual case. And I talk on here a lot. I think there are 3 prongs to movement, to creating change. Obviously, it's going to be legislatively. I'm a strong believer that there are going to be some lawsuits at the federal level that get through, and there have been some that are creating change. But that 3rd prong is dads need to be successful right now. And so at this point in time, we kind of have to play the game. You have to give yourself the best chance, the best odds at a positive outcome. And diving in and going fire and brimstone, telling the judge you're going to file federal lawsuits and RICO and demanding every judge in front of you recuse themselves, a lot of times is going to harm your case that's directly in front of you. And although you may say, hey, big picture, long run, it may help the cause, probably not. I think that in a lot of senses, if you are going to be doing that type of stuff, I know several individuals that are, you don't necessarily need to tell the judge you're in front of right now. Just go file your case. There's absolutely no reason why you need to do that and make the spectacle that it is. So that's just something I've seen, and I think there are some people on social media that are egging it on, urging it. It's just not effective. And I had a conversation with my client after we got done with our hearing that morning, and our conversation circled around how crazy she sounded, how unhinged she sounded. Her words accomplished nothing, but the way she acted definitely left an impression on the judge. So when you're going into court, especially when you're a pro se litigant and you're trying to have the judge hear you out, I know it can be a struggle at times to have the judge truly hear you out. You have to you have to really bear down and focus on what's at hand in that moment. Because when you get off topic, when you go on rants, you're probably going to lose the judge's attention, and they're probably going to lose their patience. Not saying it's fair, not saying it's right, but so I think some individuals now are losing sight of having success and maximizing their relationship with their children over being what they believe is principled when they go into court. So just something I've seen, saw it firsthand this week. I've seen an increase of it on social media. And a lot of times it also plays into the history of this movement. It's moved into the mainstream, but the history of this movement was very fringe and was painted as an angry dad's movement. And we don't want to go backwards. The father's rights movement, social medias, the biggest segment of growth are the women. Becoming more welcoming to them. I've had guests on that have talked about statistics, and there's an increasing number of women who are losing their relationships with their children, even though they're fit, willing, and able, due to the way the system operates. And we're going to need that coalition. We're going to need those individuals to make change in the other 48 states. So I'll hop in now. We'll take some questions. So we'll start out. What's going on, Andy? We'll take your question first here. So Andy asks, do you believe we have a SCOTUS which would consider ruling on a case which might grant males equal rights to parenting time? Why is there no sense of urgency? So the short answer is it doesn't really matter what the Supreme Court would do. The likelihood of a strictly custody case making it to the Supreme Court is essentially zero. There would have to be some sort of procedural or underlying issue because of the different standards. If you essentially go file a divorce case, go file a child custody case in federal court, it will immediately get dismissed. So the opportunity for the Supreme Court to rule directly on something along the lines of equal and shared parenting is almost zero. Most of the case law that we have regarding family courts involves procedural stuff. It involves benefits. It involves child welfare, like a CPS. So that there's almost no shot that the Supreme Court would end up in a situation in which they are mandating equal and shared parenting. And we also have to realize and remember that there is not a state that utilizes, there's not a specific state law that I'm aware of that sex is a determining factor. Most states actually explicitly exclude sex in their decision making. So I don't even know how much of an impact a Supreme Court decision may or may not have. And I know, Andy, you and I have had conversations and comparing it to gay marriage and how that change occurred in the Supreme Court back in 2015. I don't know if a direct case would ever make it to having that decision. So I guess that's kind of the long answer to that really only needed a short response. But realistically, we won't see that in our lifetime. That doesn't preclude a tertiary issue. I'm aware of some procedural stuff, some qualified immunity stuff that I think has some legs. But even if it gets to the Court of Appeals, the Federal Court of Appeals, it's something like the Supreme Court picks up 1% of cases that are petitioned to the Supreme Court. All right, so more of a comment here, but I think this is something that needs to be talked about and needs to be addressed more. And I see a lot of individuals doing some great work here at the Father's Rights Movement. We have the crisis hotline. Greg Ellis, in his book, The Respondent, cited men are eight times more likely to commit suicide during family law proceedings, during child custody proceedings. So it is a serious issue. It's one that I think a lot of us end up in, and we don't realize this world exists. We've never experienced it. We don't exactly know how it works, and then we end up in a situation where the most important thing in our lives, our children, are being ripped away from us, or we're having periods of time that we're going without seeing them. Um, it's something that's far too common, and it's much more common with men than it is with women. So I think it's something that discussions need to be had, uh, because it is a serious issue, and it's something we can't be afraid to talk about. I'm in a lot of the groups where men will make suicidal comments, will do things, and there are hundreds of men who jump in and are willing to talk at any time of day. I know a lot of groups. You'll see posts that'll come up where someone will post at 2 or 3 a.m. Hey, I need to talk to someone. Like, I'm really struggling. And there are individuals who are out there just willing to have a conversation. So it's a serious issue. And I think the larger we build this community, the larger we build this coalition, there's just going to be more people out there that are going to be willing and able to discuss their struggles and discuss their situations and discuss what they've been through to help men navigate through this process. One of the first pieces of advice I give any potential client is my first piece is, hey, if you can do it, go find yourself a good therapist. If you can't, if you say that's not your thing, then you need to find a family member, a very close friend, and you need to say, hey, I'm going to come to you with anything and everything. And I may just need to talk. I may need just to hear someone talk, but you're going to be that person I come to just tell everything to get everything off my chest, that I don't hide anything. I think that can also be effective. But Jacob, that's a fantastic point. So I mean, men and mental health in general, we need to be more comfortable talking about it. And this kind of adds on to it. I've been denied DV services, Ryan here. That's also a serious issue. If any of you, if you haven't seen it, it can be hard to watch at times, but it can be eye opening. The red pill. I think you can watch it for like $1.99 on YouTube. But it's a feminist went behind the scenes in the men's rights movement. And one of the points, or one of the things that's discussed at the time, there were two men's domestic violence shelters in the entire United States. And there are thousands upon thousands that service women and children. So that goes right along the same lines as mental health, or with the mental health. There's not the necessarily resources available. I think as we continue to move more and more mainstream, as these issues such as the statistics come out, you study to study, it's anywhere between 30 and 70% of victims of domestic violence are men. Most studies have it usually 40 to 60% of domestic violence victims are men. And I think as we start to come to terms with that it's not big bad man, little helpless woman, that it can be initiated from both sides, I think you'll see more services. If you're looking for something, if you're in need of something, reach out to me. And I do have some options that they can help really nationwide in terms of services, or helping you find services if you are the victim of domestic violence and do need that help. And Summer here, you make a really good point, and this goes along. More men need to reach out for help, including to domestic violence organizations. That's one of the biggest things that, and we'll tie it back into success in family court. I have clients who have been stabbed, ran over with cars, have had cars burnt to a crisp by their co-parent, and just other vile things. And they refuse to do anything. They refuse to say anything. They refuse to reach out to anyone. A couple of them, the police got involved, not by their choosing, and they refused to cooperate. And then down the line, things get nasty in the divorce or in the child custody, and the judge looks out and says, like, this happened 4 years ago, and you never did anything about it. Or you gave, even though you were severely injured, you gave statements denying she had any wrongdoing, even though all the evidence was contrary to that. So I think learning to be comfortable and understanding that there's no shame in reaching out for help, really, in any nature, in any way, there's nothing wrong with that. All right, we got Megan here. This is a really good question. So, with more and more people cohabitating with children without marrying, do you see a future for automatic legitimation of father, same as in wedlock? That's a tough question. And different states handle this differently. So, in California, all you have to do is at the hospital sign voluntary declaration of paternity, and you automatically have the same exact rights in theory as the mother. Now, I know some states, when they're a child, when you break up with someone that you have a child with, you're not married, you separate, the father has to go through a process. I think, and Florida is one of those states. I think those states could streamline that process, to better protect children and their relationships with their fathers, because it does take time to get go through that process, and in a lot of instances, it in theory could be prevented, or in theory is unnecessary. So I think a lot of the conversation in the legal community is that we're going to see fewer and fewer divorce cases and more purely child custody cases. And in my experience, and a lot of the attorneys I speak with, some cases there's always going to be, whether it be they were together for the child's 5 or the child's 3 months old, there may be questions that get raised around, are you the father? And so some of those situations, just like 50-50 or a presumption of 50-50, won't necessarily get rid of all of the issues in family court. A streamlined process won't get rid of all the issues, but it would help. So I think that's something that's going to have to be addressed in the coming decade, just because the number of children born to parents who are not married is continuing to increase. And so those states that require dads to jump through hoops, even if the child's 5 and they've been there the entire time, those states are probably candidates to create some sort of streamlined process. But at the same front, there's been a fight, in the past, around someone gets named the father, and then it was a struggle to get them removed. That's one of those situations that actually has been to the Supreme Court, where a man was found to not be the father after several years, and it ended up going all the way to the Supreme Court to get the state to stop charging him child support. So it's a double-edged sword when it comes to that, but it's something we're going to have to find better solutions for as the number of children born to unmarried parents continues to increase. We'll take another one from Summer here. So, from New York State, with the newest data coming out regarding to child maltreatment and the likelihood of mothers committing these acts, how should we use this data against DV arguments? So the data is pretty clear when it comes to child maltreatment, child abuse, deaths of children. They are significantly more likely to be harmed or even killed in the mother's care compared to the father's. And the data I've really dug into is that if it takes a look at four parties. So you have the mother's new partner, you have the mother, you have the father, and you have the father's new partner. The individual most likely to harm a child is the mother's new partner. And it's not even close. It's something like 3 out of every 4 instances of it. It's the mother's new partner. And in second, mother and father are fairly close in most studies, but most of them, it's more likely for the mother to be to perpetuate that maltreatment or that child abuse than it is the father. And then the individual in the whole situation that almost never has any issues with this is father's new partner. So, I mean, I think, how do we use this data against DV arguments? It's going to depend on who you talk to and in what context. Because obviously, women's organizations, domestic violence groups, they want to paint a very broad brush in an emotional argument. Um, and it may be hard, and they're probably just going to flatly deny a lot of the data that says child's more likely to be harmed in mom's care. Where if you're talking about in a situation where you're having a conversation with a legislator, that may be that data, being familiar with those studies, being familiar with that data, and being able to explain that could effectively sway them. Because in any of these states where we're trying to get legislation passed, the DV groups, the women's organizations, probably have lobbyists that literally have desks. They have offices right outside the courthouse, or I mean, not the courthouse, but the state house. So knowing the data and knowing your audience, I think how to use it, kind of on a broad brush. All right, so we'll take Oscar's question here. So, Oscar, judge ordered X to get a job, but still hasn't. It's been a year, and I'm going to child support court soon. Can I use this against her? So, every state's child support laws are going to be different. The short answer is yes, you can use that against her. Most states, including the state I'm in, California, they allow the judge or the commissioner that is hearing the child support matter to do what's called impute income. So, a lot of times, if they claim, hey, I can't find a job, I can't get a job, they can impute whatever income on them they deem fit. A lot of times I see it is they impute 40 hours of minimum wage. Let's just say they're underemployed, they're working part-time, they're not working at all. You see them impute minimum wage onto that individual. If they have special degrees, if they have special background, like they're a lawyer, they're a doctor, they have a master's degree, and they're not working, the judge could, in theory, impute even more than that minimum wage onto them. So it depends on your state, but if you take a look at your state laws around child support, you'll be able to see most states do allow to the judge to impute income onto them. So if you're coming back a year later and you say, Your Honor, last year you told her she needed to get a job, she hasn't, I'd request that you impute income on her, and here's what I believe she should be making. And that's unfortunately that's about that's depends on the state, but that's about all you can ask for, and a lot of times it'll be up to the judge or the child support agency if they do that. I'll take this one next here. So Clinton, they need to make law automatic paternity. So I'm assuming that you mean automatic presumed paternity to the man. That is probably a slippery slope that we don't want to go down. There are Kenneth Rosa had actually an individual on the show probably about 3 months ago who fought a years-long battle. He was on the birth certificate in the state of Texas. The state of Texas was going after him for child support. They discover he's not the father, and he spent years fighting the state of Texas for them to stop charging him child support. So, although there are certain situations where you'd like, yeah, that would be nice, that would make things easier, that would allow us to protect a child's relationship with their father, that's probably taking it a step too far down a slippery slope that we really don't want to go. Unfortunately, it's a very it's more common than I think people realize, where a woman doesn't know who the father is. And people would probably be amazed at the number of times the woman really doesn't know, but ends up guessing right, or the man who ends up pursuing custody or rights to the child is the father, even though the woman couldn't be 100% sure. So I don't necessarily think that is a direction that we need to go, but states do need a more streamlined process. So we'll take Ryan here. This is probably, I would say, one of the 2 or 3 most common questions. What about fighting false claims in court made against you? So I think that this is probably the most frightening struggle men go through in family court because of the burden of proof, because of how common they are. And the hardest thing to do is to deny or to prove that something that didn't happen didn't occur. So it can be very, very challenging, because if there's no evidence it happened, you're going to have to go find evidence that it didn't happen. And a couple weeks ago, I had Keith Flynn and Brian Jackson on from the state of Oklahoma. And you could probably go to my YouTube page, The Father's Rights Attorney. We probably have a clip of that discussion. And Keith goes into a great deal of detail as to how he attacks these allegations. So you will have some tools at your disposal. For example, you'll have different discovery tools. So number one is putting your timeline, your story together, how things occurred, what happened, what didn't happen. So you have your solid timeline. And then it's going to be about getting as much information from the other side, whether it be through written discovery, your interrogatories, your request to produce, your request to admit, and then ultimately probably the number one tool. It doesn't get used a whole lot because of time and because of expense. But if you're able to do it, if you're fighting false accusations, if you can get an attorney to do a deposition, to dive into your case, get your timeline put together, and then depose the other party, that's probably the most effective way to attack those issues, because it can be increasingly frustrating. Because a lot of times it ends up being he said, she said. If she's claiming on Tuesday, July 21st, you shoved her in your home and the kids were in bed, there's not going to be any evidence, most likely, unless you have security cameras in your home. There's not going to be any evidence it happened. There's not going to be any evidence that it didn't happen. And so it's going to be about putting as much information together as possible. And a lot of times that means getting the other party who's making the accusation to have to speak on the record as much as possible, and you can kind of pick apart their story. So we'll take KM Ross here. So how do you get the mother's new baby's father's income? So I'm thinking you're saying the co-parent's new partner's income included when considering child support. He provides for, but they aren't married, so she's just on welfare and collecting child support, even though we have 50-50. So once again, child support is state by state. Here in the state of California, a new partner's income for purposes of child support is almost irrelevant. So essentially, the only time it comes into play may be pushing you into a new tax bracket and actually lowering your child support obligation. So unfortunately, in the state of California, and you see this some, they get a new partner, they make no, they don't work, the new partner supports them, then it doesn't get included for purposes of child support. So essentially, what ends up being is that person's spending money, that person's fund money, is dad paying child support. It can impact spousal support or alimony. In the state of California, that is included for purposes of alimony. If someone else you're cohabitating with someone else, you're married to someone else, that can definitely impact it. And I would tell anyone that's getting divorced that is going to come to some sort of settlement agreement on their divorce to ensure if you're going to be paying spousal support or alimony, that you explicitly put clauses in there that spousal support or alimony, in California we put in there's a presumption that less spousal support is needed if you if you're cohabitating with someone. And a lot of times marriage just ends the spousal support altogether. So you want to make sure if you're going through a divorce, you're going to have to pay spousal support. You're going to want to make sure things like that are included. But in a lot of states, the new spouse's income or the new boyfriend's income, the new girlfriend's income won't come into play when it comes to child support. But once again, it can go back to if they're not working, that may be a situation where you request the courts impute income onto them. So Ryan again here. Should I report to the authorities my ex-wife calling my father, telling him people are hunting me where I live? Yes. That is a death threat, and in most states, if it can be proven, that could be a felony. So that's something that's very, very serious. And if there's no proof or no evidence of it, unfortunately, the longer you wait before reporting it, the less serious authorities are going to take it. But if you're getting threatened in any way, your immediate response should be to let the authorities know that that is occurring. All right, so we'll take Nate's question here. So Nate asks, what can I do if my ex left with my oldest daughter and she signed a summons to the court before leaving and she never went? So moveaways, different things like that are going to be different in different states. So the standard in California is, and it's this way in a lot of states, once a case is opened, once a case has been started, and child custody, even if there's been a final judgment, if there's been a settlement, whatever it may be, child custody is always considered an open issue until the child turns 18. So in California and a lot of states, if there's an open case, if there's an open case, then she either has to get written permission from you or court approval. So in California, especially over the last year, it's not been uncommon to we've seen an increase in move away cases. Parents looking to take their children to places where it's open or more affordable to live, but they can't just go do it on their own, and it's usually frowned upon. So based on my reading of your question, it sounds like you have an open case, which I would most likely want to file immediately for an emergency hearing, an ex parte hearing, to get in front of the judge and let them know what happened. If you don't have an open case, in theory, if there's no open case, both parties can do whatever they want with the child. And so if there wasn't an open case and she did that, the state you're currently in, if this just happened, probably still has jurisdiction, and you need to be down at the courthouse filing the appropriate paperwork to get that case started. In a lot of states, moving away, doing something like that is enough to get an emergency hearing granted and get you in front of a judge quicker. So, and on the front of if a case had just started and she left and she isn't responding, anything like that, each state's going to have their own process for what we call defaults. As some of you have probably learned firsthand, if you don't participate in your divorce process, then it will move on without you, or your child custody process. They will move on and make orders without your participation, and you probably won't like them. So if a case is started, a case is open, a case is pending, you probably need to talk to a lawyer locally, or at least in your state, on if you can file for default. All right, so we'll take JM's question here. I have custody of my two daughters, and I've requested child support, but it has been 4 months and the judge still hasn't made the mother pay child support. What can I do? So, if it's anything, I don't know what state you are in, but if it's anything like the state of California, if you go to the Department of Child Support Services today and request the paperwork and fill out the paperwork, you may be 6 months out before you get in front of a judge to get child support ordered. By the time Department of Child Support Services or your agency in your state gets the paperwork submitted and gets you a court date, I know right now in California we are like 5 months out, so it may be more than 6 months. The time you go to the courthouse, get the paperwork filled out, and then get a return date to be in front of a judge. If it's tied to your custody case, you may have to. Some states require you to motion for judgment. So it's child support, again, very, very state specific. A lot of states, including California, Texas has some wild laws around this, but they will backdate child support. One of the things in California that gets a lot of guys is the fact that they will backdate it to date of filing. So let's just say in June or July in California, you filed for child support, and you're not going to get into court until January 2022. They can backdate that child support, and let's just say for round number's sake, you get ordered to pay $1,000 worth of child support. Well, they can go back and say this was filed in June, so we're going to go June, July, August, September, October, November, December, January. Okay, so your balance right now is $8,000 in child support. So a lot of states are able to do that. Whether you have to ask for it or it automatically happens, it may vary from state to state and how aggressive states are. Like if you're in the state of Texas, they're extremely aggressive about going after child support. You probably don't even have to ask. Other states, you may have to ask and see exactly what the laws say they can do. It looks like you followed up here. So it looks like you're in Massachusetts and you're already in front of a judge, waited 8 months to be heard. Unfortunately, the post-COVID era we're in, I just today got court dates into February and March on a couple cases. So It's an unfortunate piece of what we're dealing with right now. I would say if you have an attorney, you need to talk to him about what the process is to gain some clarity, gain some understanding. If you're doing it pro se, if you don't, it may be worth paying a little bit of money to a consultation, or doing some of your own research. Some law firms in your state probably have some blog posts about exactly what needs to be done to make sure you've checked all the boxes to get that order and to get child support started. I'm not even going to read this full question before we put it up here. I just see interesting issue from Jefferson. So, ex-wife before court went homeless 5 days after my daughter was returned to her mother. She failed to notify the judge during the modification hearing. Could that be considered bad faith if after court she says they are now homeless? We have evidence of repossession of property was August 19th, and she returned on the 14th. Court was September 3rd. So I think that's probably a situation where she may fall in a little bit of a gray area. I think we would probably look at it and say ethically, if she's demanding a modification, if she's trying to gain more custody and she goes homeless in the process, she should probably let the courts know. That's probably something the courts should inquire to. I know that one of the big things we always do with men, when I represent them, is we lay out what the living situation is going to look like very specifically. They're going to have their own bedroom, or they're going to sleep. They have their own bed, but they're going to sleep in the same bedroom. This is their support system. So that's probably grounds to get back into court on and say, hey, they're homeless. This is a serious issue. My daughter's in danger. She doesn't have appropriate living situation. But from my experience in a post-COVID world, judges have been very, very lenient towards living situations. In the past, I've seen where, hey, if you don't have their own bedroom, if you don't have their own bed, whatever it may be, they come down hard, and they're very limiting in terms of what custody is. But I would say over the last 3 to 4 months, especially in situations where it's like dad has one bedroom or mom has one bedroom, they aren't as punitive in the way they rule. So I think that's probably the judge may not appreciate it. That's probably the way I would want to frame it, is like, hey, Your Honor, they misled you. They intentionally misled you. They failed to disclose material facts of their situation to ensure that they got an outcome more of what they wanted, and make it seem like they kind of bait and switch the judge. But I don't necessarily think there would be anything punitive, because in a post-COVID world, judges I've seen have been very, very careful when it comes to living situations and people going through hard times financially. All right, we'll take Ty's question here. We'll probably take 2 or 3 more questions, so go ahead and get your questions in the comments section. So apparently my ex has decided to represent herself during our mediation. I don't understand why, and neither does my lawyer. What does this say to the court when she shows up by herself? How does this play out in mediation? So I don't think on its face the judge or the mediator, depending on your state, how they do them. I don't exactly know the situation. Is a mediation position where the judge is going to get involved to try to get to a solution, or is this court ordered, private mediation, whatever it may be? But I don't think they'll look at it on its face and have an issue, but you have an advantage. So your attorney should be able to educate you, should be able to tell you generally what's going to happen, should be able to tell you what to expect, and should help you get your thoughts in order. So I had Alabama attorney Michael Lambert on probably about 3 months ago, and he's a mediator, and we spoke on that. And one of the things your attorney should be doing is helping you put together a list of things that matter. So going in knowing the 2, 3, 4 things that really, really matter to you, so that you're more prepared to be able to come to a resolution. A lot of times I see pro se litigants get tied up either in they don't trust the entire process, and so they end up making outlandish requests and they lose sight of what they actually want. I see them, they get bad advice from people. I see this very commonly where they'll say fire an attorney who's going to get them a good deal and get this situation settled. And then they start taking advice from their aunt who has been divorced 4 times and thinks she's a human child support calculator and knows everything there is to know about courts and child custody. So you have an advantage. I don't think the courts are going to necessarily hold it against her. I would say your odds of coming to a resolution when it's pro se, when either side or one side is pro se, are probably less than if both are represented. In my experience, a lot of times when not all the time, and it may not be your specific situation, but a lot of times when women will fire their attorneys leading into something like this, we'll be very, very, very close to a deal. We'll be her attorney and myself maybe on the same wavelength on what we need to do or what we need, and because of that, and they think they deserve more, they want something different, they'll fire their attorney because they think they can get more, they can do a better job themselves. So I always tell clients when the other side fires their attorney and goes pro se or is just pro se from the beginning, it just makes things a little bit more unpredictable. When you have counsel on the other side, there's a lot of stuff that kind of how it's going to go down. So that would be my only piece. It's you're probably less likely to get a deal done, but going into mediation, you need to focus on yourself and what you really want to get as good an outcome as you possibly can. All right, so we'll take Luis' question about child support here. I have a very serious question. According to California, I owe $84,000 in arrears, which I am paying since it was put into order in 2015. The original amount was $42K. Apparently, they are charging interest for being behind and owing interest. I cannot and will not ever be able to pay this amount. My ex committed adultery while I was deployed in Iraq and left for some other dude ever since '08, and I agreed to a verbal agreement at the time to give her only a certain amount of child support. Let me see if the only let me see on here this far down. So in the state of California, right now they have a program going on around for if you make certain payments around forgiving some interest, which a lot of times would go to the state or essentially forgiving portions of money that the state would normally collect. So I would, number one is I'd reach out to your local child support agency and see if they are what they're doing right now, how they can help you. Unfortunately, usually without the help of your co-parent, you're not going to be able to get what the money that's owed to her to be forgiven. And in regards to having the verbal agreement, this is why you always go through the court. If you agree to something, you need to go get it consummated through the courts so that something like this doesn't happen. If she's claiming you didn't pay her child support when you were paying her child support, that's something that you probably need to bring to the Department of Child Support Services attention. But sometimes just the way that the laws are set up, child support, when you get behind on it, can be challenging. I'm helping out with a situation right now where the former couple actually pulled child support out of the courts did it privately for 3 years before they went back to the courts. Well, dad's done paying child support now, and mom's going back and wants those 3 years audited, and dad was paying her cash during that time. So it's one of those things that you have to look into the specific situation. The first phone call I'd want to make would be the Department of Child Support Services to see what they're able and willing to do. If you're talking about $42,000 in interest, you may be able to cut some sort of deal. If you're able to pay some sort of lump sum on it, that can at least make that amount manageable. All right, Charles, this is a really good question. So, have you ever had a client or know anyone that has sued the city and CPS for negligence, psychological abuse to yourself, and keeping your son from you? Um, so, I was originally trained as a labor and employment attorney, um, and worked for a period of time as a management side labor and employment attorney. And my firm represented the city of Chicago and the state of Illinois. Um, those major cities get sued all the time and have gigantic slush funds to pay out settlements. Gigantic slush funds, like millions of dollars, tens of millions of dollars. And so I have seen situations where the city's been sued for different things. So CPS, though, and involving child custody, you would probably have. So, number one is we've seen, depending on the state, we have seen that they grant certain agencies qualified immunity and they grant certain individuals qualified immunity. So, you may run into that with CPS, and you would probably have to. You'd probably have to prove actual bad intent on CPS's part to get that going in any direction. I do have one situation right now where Child and Family Services, which is what California calls Child Protective Services, in a county didn't find that abuse had been occurring. And then a couple months later, statements were made to police that it in fact was occurring. And we feel like Child and Family Services is trying to cover their tracks because they maybe didn't do as thorough an investigation as they should have. So I currently have a situation like that where we're trying to navigate through, but that's an ongoing custody piece. So the lawsuit against CPS or a city would kind of be a back burner, but that could be that would be something interesting. But I don't know how exactly you would tie the city into it, but CPS definitely has been sued a lot. There's a lot of instances. So Connie Reguly, who's been on this show before, she's had a couple of very well known cases in the state of Tennessee. She does a lot of advocating for children, and she's had a couple of cases where they have went at the local welfare agency and been successful. So it's definitely happened. But it's going to depend on the setup and what your state allows and what you're actually able to prove. Because I find that the biggest challenge a lot of times with these with these, say, child endangerment, child abuse, maltreatment, is what can we actually prove and what is just the conclusions we've come to. You can't walk in and say, hey, I think child abuse is happening, because there's a good chance that if you have no evidence, if there is no other evidence of it than what you're saying, they're going to find it unsubstantiated. So I think you would probably have to find you'd actually have to find someone who intentionally did something wrong. But it's definitely happened. Or someone who's gotten too aggressive and not followed policy and procedure about taking a kid out of a home or that type of thing. So it's definitely possible. You have to take a look at the specific situation, though. All right, we're about 55 minutes. I'll take one more question. All right. So, Shraja, this is more of a comment. We'll still take one more question. But so, yeah, Oklahoma actually just a couple weeks ago talked to Keith and Brian about that. Oklahoma here in the next couple of weeks are going to have a couple of laws go into place. They were one of the states that got facts, findings, and conclusions of law included in their new laws now that passed this past year. So, if you're in the state of Oklahoma now and the judge makes a decision, they will have to provide facts, findings, and conclusions of law. So they're going to have to state their reason on the record. Kind of the first step. Tennessee got something similar. West Virginia got something similar this past year. So a little bit more accountability to judges. And I believe Oklahoma is going to be one of the states that's going to have a 50-50 bill get introduced again this year, and hopefully build on the momentum of this past year. I'll take Charles' question here. So, what are we doing in California to get dad's 50-50 rights? So, specific to the state of California, to be very candid, I've personally had conversations with a handful of legislators, and there's not much movement on that front. It's one of those things. There are some individuals who are willing to support it, but there aren't many people at this moment that are in the legislature, in the state assembly, in the Senate, who are willing to put their name on it. And that's something we've seen. Most of the states that have had movement, you think Kentucky has their 50-50 law, a red state. Arkansas has their 50-50 law, red state. And then you take a look at the states last year, West Virginia, Oklahoma, Tennessee, Texas, that passed different laws. They're red states. Texas actually on their Republican Party, although it's not a partisan issue, it's tended to be the first moving states have been the red states, have been the more conservative states. And I think that the direction we've tried to take it and the direction that we've tried to move the conversations is we're obviously being very child centric, and knowing that I've targeted and have a handful of people working with me that have targeted legislators who run big on education or child development, and talking about the benefits of having both parents involved when it comes to high school graduation, college grades, school suspensions, teen pregnancy, healthy relationships. So we have had some productive conversations with legislators who typically support education-based bills. But being quite frank, they're at this moment, last I heard, 12 states that were going to have 50-50 bills get introduced this year. Realistically, California is probably further down the line than some of these states that we're hoping are in the next couple of years. So, yeah, if you're interested in getting involved, Charles, DM my Facebook page, and we can make sure you get on the list. We do occasionally have Zoom calls where we've educated people, where we get people started, and we really want people statewide to be able to reach out to their specific assembly person, their senator, because that a lot of times is the most effective. Hey, I am one of your constituents, and here's a concern I have, rather than say me being in Riverside County reaching out to someone in Sacramento or someone in the Bay Area. So yeah, just drop me a DM at the father's rights attorney, and we can get you on the list to get you involved to the level you want to be involved. And I'll tell you this: whether it be the fathers' rights movement, which are obviously broadcasting on their social channels right now, or any other group. Find a group that fits best with you, and volunteer some time. Their groups are always looking for individuals, whether it be to help run social media, to help contact legislators. We're going to be getting into a season here in the next 2 months. A lot of states, these states that are going to have bills get introduced, we're going to start seeing those bills pop up, and legislative sessions are going to start right after the first of the year. And so everybody's going to be looking for volunteers to be able to visit state houses, hit the phones, do things like that. So you can definitely find a home if you're wanting to help move this forward. There's any number of groups. If the fathers' rights movement's not the fit, whether it be Americans for Equal and Shared Parenting does phenomenal work. There's a couple groups based out of the state of Texas that do phenomenal work. Find a group, volunteer some time. It'll also give you some perspective of some people who have been in the fight for a long time. So with that, we will wrap up our show tonight. I want to thank everyone for listening in, and we will be back next week, Thursday, at 8 p.m. Eastern Time, 5 Pacific. And I promise you, we will have a guest next week. So we'll go back to our interview format next week. So we'll see you guys next week. Have a nice night.